Hello, good evening. Hello, everybody. Hello, welcome in. Welcome in. Good to see you. I have turned comments off as I start tonight. I will be reading through a court order and then I will turn comments back on once I have finished reading. So, hello, John. Hello, Frank. Good to see you. Good to see both of you. Hello, welcome, everybody. Welcome. So, as promised, I do have the Jennifer Crumbley case. So, this is a case involving a mother and father who have been charged with a degree of homicide, so manslaughter in Michigan, for the conduct of their child. So, I do have our live set for 18 and older tonight. And I will be careful with my words. There are just a few words here that I know can be a little bit triggering. But I have for us tonight the State of Michigan Court of Appeals decision. So this case, everyone, is setting new precedent. We haven't had parents of a school shooter prosecuted before. So we're in new territory. What had happened was it had been appealed to see whether or not there was even grounds in order to bring this case against the mother and father, and the state of Michigan decided yes, there were grounds, and so that is the opinion that I will be reading today. It does go through the facts of the case, and so I would highly recommend viewer discretion. I will be careful with my language, but also this is a homicide case. So we do have some lives that were lost. But I will be going through this. I think the opinion really sets out the facts very, very well, as well as the procedural history. So as we know, Jennifer Crumbley has been on trial this last week. And the jury has been put into deliberations this morning. So they are deliberating right now as we speak, although I think they've gone home for the day, come to think of it. But they are deliberating. They did a filing where they asked to be tried separately, which I think was a very smart decision to be tried separately. So Jennifer is first, and then Mr. Crumbley will be tried separately in a separate trial. So her trial has been going. We have a jury that is out for deliberations, and so that is the update, everybody. So I will take you through this opinion again. I will turn on comments once I finished here going through the opinion, so we can kind of talk about it a little bit. So this is a very sad case involving all the characters here. So just to give you a visual real quick before I start reading, this is the Crumbleys here. This is Mrs. Crumbley, Jennifer, and then Mr. Crumbley here. So these are the parents of the boy who unalived multiple kids at a school. So they have both been charged, and today we have the jury out for Mrs. Crumbley, and we will have the next trial going for Mr. Crumbley soon. So I'll go ahead and get into the appellate decision that allowed for them to be taken to trial to begin with, and then I will turn on questions and comments later. So hopefully I am well enough in frame here, and this is available online for anyone who is interested. This decision was made March of 2023. I have been watching this case since early last year because it is really groundbreaking because it involves the parents. So this was a decision delivered by Judge Murray out of the State of Michigan Court of Appeals. Defendants James and Jennifer Crumbley are the parents of E.C. who shot and unalived 4 fellow students and injured many others at Oxford High School on November 30th of 2021. EC pled guilty to 4 charges of first degree. In these proceedings, the state has charged defendants with 4 counts of involuntary manslaughter related to those same deaths. At the conclusion of the preliminary examination, the district court concluded that there was sufficient evidence presented against defendants on these charges, including sufficient evidence of causation, and bound them over for trial. In a written opinion, the circuit court subsequently agreed and denied defendants' motion to quash the charges. This court denied defendants' application for leave to appeal that decision, but the Supreme Court remanded the case back to us to consider whether there was sufficient evidence of causation to bind the defendants over for trial on the charges of involuntary manslaughter. So we have our first footnote, number 1 here, which are citing the 2 cases and docket numbers here. So, background, preliminary exam evidence. So what's so great about this opinion, everyone, is it does really explain this whole process of what we need to have in order to go forward on indictments. So we have number 2 here. In our recitation of facts, we focus only on the evidence relating to the discrete issue on appeal. Defendants, a married couple, lived together in Oxford with EC, who was 15 years old at the time of the murders. Jennifer worked full-time in the marketing department of a real estate company, while James worked for DoorDash, a food delivery company. Although it is unclear from the record exactly when evidence of his problems first arose, the record is clear that by early of 2021, EC began verbalizing situations he was experiencing that reflected instability in his mental health. For example, in March of that year, EC sent a series of text messages to Jennifer explaining his desire for Jennifer to come home, sending messages in close temporal proximity describing his self-described paranoia that someone was in the house, flushed the toilet, and left the light on. And I thought it was you, but when I came out, there was no one home. There is no one in the house, though. And dude, my door just slammed. About 10 minutes later, when Jennifer had not responded, EC sent another two text messages stating, maybe it's just my paranoia, and asking, but when are you going to be home? Jennifer did not respond until the next morning. According to defendants' cell phone records, neither defendant called EC that night. So Jennifer is his mother. About 1 week later, EC sent additional texts to Jennifer, this time reflecting his belief that a demon was in the house, that it was throwing objects in the house, and that he had taken a picture of it. Okay, the house is now haunted. Some weird stuff just happened, and now I'm scared. I got some videos and a picture of the demon. It is throwing bowls. I'm not joking. It effed up the kitchen, and I'm just going to be an outsider for a while. When Jennifer did not respond quickly enough, EC wrote, can you at least text back? Jennifer did not text back at any time that day, and her cell phone contained photographs showing she was taking pictures of James and herself riding horses at the time the messages were sent. Approximately 2 days later, Jennifer messaged James about how EC was doing, and James responded that he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer was not surprised by EC's state, telling James, well, EC was really worked up and out of control, so I can see why. Jennifer sent another message. All I know is he needs to eat, go to work, and work hard and not complain, and he can get his stuff back. James then relayed something EC apparently said that morning. He said, let me ask you a question. Why am I in your guys' room? Laugh out loud, LOL. Jennifer responded, OMG. And James said, I totally thought you were giving him Xanax last night. Jennifer stated she gave EC melatonin, a natural sleep aid. EC continued to experience hallucination-type events for 2 days later. On March 20th, EC sent Jennifer several text messages in quick succession. I cleaned until the clothes started flying off the shelf. This stuff only happens when I'm home alone. And I picked the clothes back up and thought. Once again, Jennifer was at the barn when those messages were sent, and she did not respond. The most prolific text message conversations were between EC and his best friend. And we have footnote 3 here. There was no evidence that either defendant saw the text messages between EC and his friend, though the evidence did show that defendants had access to the information as EC's phone was registered to James. Just after midnight on April 5th of 2021, EC sent text messages to his friend telling him he was going to ask my parents to go to the doctor's tomorrow or Tuesday again. But this time I'm going to tell them about the voices, and I only told them about the people I saw. Amongst other things, EC told his friend that he had researched his symptoms and believed he was having a mental breakdown. True to his word, EC informed his friend that he had asked his parents for medical help, but that James refused the request, instead giving him some pills and telling him to suck it up. Jennifer, according to EC, laughed at the request because she did not believe he had any mental health issues, but was instead using drugs. This made EC feel like the S word, such that he considered calling 911 so someone would take him to the hospital where he could get help. EC decided not to do so, he said, because defendants would be angry with him. Communications between EC and his friend were about more than just mental health issues and problems with defendants. While many of the messages contained normal teenage banter, others involved conversations about wanting guns and making plans to buy them. For instance, 3 months before the shooting, EC sent his friend an 11-second video showing him loading a magazine into this weapon registered to James. EC's friends responded, "Nice," and then wrote, "Now pull the trigger, just kidding, JK. EC responded that my dad left it out, so I thought, why not, LOL, and I know safety, so it's no problem." EC then said, "Now it's time to do this with the school," and JK. By October of 2021, 7 months after the first message and evidence on the topic, EC and his friend were still discussing EC's belief that he was having a mental breakdown. Defendants' text conversations during the same time period show no indication that they considered finding some help for EC. Near the end of October, EC's conversations with his friend via text message stopped. Then the Crumbley family dog and one of EC's grandparents died. Jennifer told Kira Pennock, and then we have a footnote 4 here. Pennock owned a barn where the defendants housed their horses. She believed EC was having a hard time because he lost his only friend, his dog, and a grandparent, all in quick succession. According to Pennock, Jennifer did not speak about EC often, but when she did, she described him as weird and said he had no friends. Amanda Holland, one of Jennifer's co-workers, testified that Jennifer described EC as quiet and brought up concerns about him feeling lonely after his friend moved away. Jennifer did not speak to either of them about getting help for EC. EC also kept a journal. In footnote 5 here, evidence showed the defendants were aware of the journal, but no evidence was submitted that either read its contents. The journal referenced his friend, contained a drawing of a decapitated bird, depicted a demon, and discussed various other issues in EC's life. Every one of the 21 pages of written material had reference to plans to commit this act. In one entry, for example, EC wrote, "I will cause the biggest situation in Michigan's history, and I will harm everyone I see." EC also described a specific plan explaining the first victim Has to be a pretty girl with a future so she can suffer like me. The same page contained a drawing of a girl being harmed. EC partially blamed defendants in the journal, writing, I have fully mentally lost it after years of fighting with my dark side. My parents won't listen to me about help or a therapist, and I have zero help for my mental problems, and it's causing me to do this activity at the school. On November 26th, James and EC went to a shop because James wanted to purchase a 9mm. To make this purchase, James provided his identification, filled out and signed the required form, and waited for completion of the background check. The form James signed indicated that purchasing this for someone else was illegal. When the background check cleared, James purchased the object, which was given to him in a case containing a cable lock, a trigger lock, an ATF Youth Handgun Notice Act pamphlet, and extra magazines of ammunition. We have footnote 6. Amongst other things, the ATF pamphlet warned that the misuse of these items is a leading contributor to juvenile violence and fatalities. Later that same day, EC posted 2 photographs and a video on his Instagram account. Both photographs were of this item, and the video showed EC holding the item. In the background of the video, the case, the ATF pamphlet, and the unopened lock are visible. The caption on EC's Instagram post stated, just got my new beauty today, heart's eyes emoji, Sig Sauer 9mm, ask any questions I will answer. The next day, Jennifer took EC to a shooting range. Upon arrival, Jennifer purchased 30 minutes of range time, paper target, and 2 boxes of 9mm ammunition. A surveillance video from the range showed Jennifer and EC firing the item. EC went first, and then he showed Jennifer how to load the item and helped her shoot it. Afterwards, EC took the item apart, put it back inside the case, grabbed the used paper targets, took the leftover ammunition, and left with Jennifer. Later that day, EC posted on his Instagram account a photograph of the target with bullet holes through it, with a caption stating, took my new SIG out to the range today, definitely need to get used to the new sights, LOL. Jennifer posted photographs of the paper target and the item in its case on her own Instagram account, captioning her post with, Mom and Sunday testing out his new Xmas present. My first time shooting a 9mm, I hit the bullseye. Although there was no way to verify whether defendants saw EC's Instagram posts, their cell phone records show they did follow his Instagram account. In the early morning hours of Monday, November 29th, Jennifer performed an internet search on treatment options for clinical depression. Later that morning, EC was back at school. While in class, a teacher saw him looking at ammunition on his cell phone. The teacher informed Mr. Ejak, Dean of Students, who forwarded the message to EC's school counselor, Hopkins, and another school official. Hopkins and the official met with EC that day and asked him about his cell phone activity. EC explained he was looking at ammunition because shooting was a hobby, and he had just gone to the shooting range with Jennifer, his mother, and wanted to look up different bullets. Although EC was compliant, calm, and understanding during the meeting and acknowledged researching ammunition was not a proper classroom activity, a school official attempted to contact Jennifer about the incident, leaving a voicemail explaining that these things may be a hobby and there's nothing wrong with that, but that it was improper classroom activity. The official did not request Jennifer call back, and she did not do so. After receiving the voicemail message, Jennifer began to text message conversation with EC that same morning. Jennifer wrote, seriously, looking up bullets in school? EC responded almost immediately and sent a string of messages in quick succession. What? Oh yeah, I already went to the office for that. It was in first hour. All I did was look up certain caliber at the end of class because I was curious. It was on my phone, completely harmless. The teachers just have no privacy. They said, I'm all good. I understand why they talked to me, and they said that I am good. And this is nothing I should get into trouble about. Jennifer wrote back telling EC that he was not in trouble and she just wanted to inform him. The school left her a voicemail and added, did you at least show them the pic of your new weapon? EC followed up with another string of text messages to Jennifer, his mother. No, I didn't show them the pic. I only told them I went to the range with you on Saturday. It was a harmless act, and I have this bullet cartridge in my room, and I didn't know what kind of bullet it was. It said it was a .22, so at the end of first hour, I just looked up different types of .22 bullets, and I guess the teachers can't get their eyes off my screen, shaking my head. SMH. Jennifer responded by writing, LOL, I'm not mad. You have to learn not to get caught. EC texted JK to hide his JK LOL with laughing emojis, asked to listen to the voicemail and explained that he was not trying to hide his cell phone, but did not know a teacher was looking. Jennifer told EC she saved the voicemail and then spoke briefly to a coworker about the voicemail. According to the coworker, Jennifer did not seem concerned about the message. On the morning of November 30th, Jennifer went to work, James went to the barn to check on a sick horse, and EC went to school. Just as a reminder here, this is Jennifer, the mother of EC, and this is James, the father of EC. In EC's backpack were the Sig Sauer handgun in his journal, and footnote 7 here. The last entry in EC's journal was written the day before, where he noted that he had the item and ammunition, specifically mentioning the 9mm Sig Sauer, and proclaimed the school situation would be the next day. EC also wrote, forgive me, in big bold letters. While in English class, EC was caught watching a kind of video on his cell phone, which the teacher reported to EJAC. EJAC forwarded the message to Hopkins at 8:30 a.m. By the time Hopkins saw the email at 8:50, EC had switched to math class. At about the same time, another message was delivered to EJAC from EC's math teacher, who had photographed EC's handwriting and drawings on a math worksheet and attached it to the message. And this is the drawing here that was submitted into evidence of his math sheet. After EJAC went to Hopkins' office to discuss the math worksheet, Hopkins went to EC's classroom, grabbed the worksheet, which EC had already attempted to modify, off the desk, and walked EC to the office. The modifications EC made to the original worksheet were significant. As for redactions, EC scribbled out the item, which I will cover up now here, which closely resembles the Sig Sauer. The person bleeding from bullet holes in the phrase, help me, my life is useless, the world is this, and blood everywhere, added to the worksheet were statements that I love my life so much, harmless act, we were all friends here, and OHS rocks. And video game this is. The modified worksheet provided a more complete picture of how EC tried to cover up what he initially wrote and drew. When questioned by Hopkins, EC said the video was of someone playing a video game, not an actual event, and that he enjoyed video games and was considering designing them as a career. Hopkins then asked EC about the math worksheet, which EC said was a drawing about a video game. After Hopkins asked EC about the statement that my life is useless, EC's demeanor changed. According to Hopkins, EC became sad and started discussing his various troubles in life, specifically mentioning his friend moving away, difficulty dealing with the restrictions put in place to address the COVID pandemic, and his dog and grandparent dying. EC also mentioned that he argued with his parents the night before regarding his grades. Noting a concern about EC's mental health and particular ideation, Hopkins performed a risk assessment related to EC. Hopkins then left a voicemail message for Jennifer and called James, who also did not answer. Jennifer eventually returned the call and was asked to come to school to discuss EC's situation. Hopkins forwarded Jennifer photographs of the math worksheet before and after modification. This is after modification here. While they were speaking, Jennifer informed Hopkins that she would contact James to see who could come to school. In the meantime, Hopkins waited with EC. Soon after the phone call, Jennifer attempted to contact James via Facebook Messenger, stating at 9:33 a.m., "Call now, emergency." In the following message, Jennifer attached both math sheet photographs. Make sure I'm in frame, everyone. James responded at 9:44 a.m. "My God, WTF." Immediately afterwards, James informed Jennifer that the veterinarian still had not visited Pennock's farm to see their ill horse. Jennifer stated she thought EC was distraught about the night before and asked James to call her because she was driving to the school. Jennifer and James spoke on their cell phones for about 7 minutes before both arrived at the school. When defendants walked into Hopkins' office, they did not greet, touch, or hug EC, which Hopkins called bizarre. Hopkins informed defendants about the video EC had been watching during his first hour class. He had already sent Jennifer both versions of the math worksheet, told defendants that he was concerned about EC's mental health, provided them with mental health resources, and recommend they immediately take EC to a doctor or a therapist that day. Jennifer objected to that suggestion, opining that getting EC care on that day was impossible because she and James had to return to work. Footnote 8. According to the chief operations officer at Jennifer's employer, the company was family friendly and Jennifer would have been permitted to either work from home, bring EC to home, or use paid time off, PTO, on November 30th. Kathy, a human resources director for Jennifer's employer, testified that at that time Jennifer had 12 hours of PTO available. James did not disagree with Jennifer's statements, despite his surprise at the decision. Despite his surprise at that decision, Hopkins insisted that EC get medical attention within 48 hours. Because there was no disciplinary issue requiring EC to leave school, the decision was made for EC to remain at school. Hopkins believed it was good that EC would not be alone, considering the concerns about his ideation. During the nearly 15-minute meeting, Jennifer did not speak to EC. James, on the other hand, expressed to EC that he had people with whom he could talk, including defendants, and encouraged EC to write in his journal. Hopkins testified that Jennifer abruptly asked if the meeting was done, and Hopkins checked with EJAC before everyone left. On their way out, neither defendant hugged or said goodbye to EC. Hopkins, though, told EC, "I just want you to know I care about you," because he did not believe EC was getting parental support. Hopkins doubted whether defendants planned to get EC help, so he planned to meet with EC the next morning to see how he was doing. Neither EJAC, Hopkins, nor defendants asked to or looked inside EC's backpack, which contained his journal and the Sig Sauer. Surveillance footage shows defendants leaving Oxford High School at 10:54 a.m. and driving out of the parking lot at 10:56 a.m. 2 minutes later, Jennifer contacted Pennock to discuss a horse riding lesson scheduled for that evening. Jennifer told Pennock about EC's issues at school and forwarded photographs of both versions of EC's math worksheet, but said she still planned to come to the lesson, though with EC. Pennock testified she was alarmed by the violent drawings and was aware that the Crumbleys owned weapons. Pennock recommended equine therapy for EC, to which Jennifer responded Yeah, well, he'll be coming out with me tonight. James is working. EC can't be left alone. Pennock asked if EC would want to ride a horse, to which Jennifer wrote, maybe brush a small horse so he's not intimidated. Lol. While Jennifer messaged Pennock, James logged onto DoorDash and accepted his first delivery job at 11 a.m., just 4 minutes after driving out of the school parking lot. Jennifer returned to work where she spoke with coworkers about the school meeting. Jennifer reiterated her concerns about EC being lonely, given recent events in his life, and showed both of them EC's math worksheet. Jennifer said she felt like a failure as a parent, agreed with the assessment that the drawings were disturbing, and that EC needed counseling, and reiterated that she felt like a failure as a parent. One coworker, however, also sensed that Jennifer was being sarcastic regarding the situation. At 12:21 p.m., Jennifer sent a text message to EC asking if he was okay, and he responded he was and had just finished lunch. Jennifer then wrote, "You know you can talk to us and we won't judge," to which EC responded at 12:42, "IK, thank you. I'm sorry for that. I love you." Fewer than 10 minutes after sending the message, EC went into the bathroom with his backpack and came out with a Sig Sauer and committed the murders while also injuring 6 other students and 1 teacher. By 12:58 p.m., the shooting was over. Oxford High School sent out alerts to parents about an active shooter within the school. Jennifer received the information while at work and started screaming. Upon receiving the alert, James drove home and unsuccessfully searched for the Sig Sauer and ammunition. At 1:18 p.m., Jennifer responded to EC's last text message by writing, "I love you too," and asking, "You okay?" 4 minutes later, Jennifer told EC, "Don't do it." James apparently had informed Jennifer of the missing item and ammunition because she sent the following text message to a coworker at 1:23 p.m. "The item is gone and so are the bullets." Jennifer then called James and, while sounding frantic, said she was attempting to get to the school and expressed concern that EC was going to commit self-harm and that EC must be the shooter. At 1:34 p.m., James called 911 and told the operator his son went to Oxford High School and that James's item and ammunition were missing from his home. James relayed information about the school meeting and expressed concerns that EC took the weapon and was the school's shooter. Pennock testified that when she heard the news of the school shooting, she immediately thought EC committed it. Given the drawing on his math worksheet and the defendant's ownership of a certain item, Poliquin came to a similar conclusion, adding that she was aware of Jennifer's Instagram post about purchasing this item for EC. On the day of the shooting, police executed a search warrant for defendant's home. In defendant's bedrooms, Detective Adam Stoyak found the gun case for the Sig Sauer open on the bed next to an empty box of 9mm ammunition and a locked gun safe in a dresser drawer of the defendant's bedroom. The safe had a 3-digit combination lock, which was set as 000 and contained James's other 2 items. All of the locks found in the house were still in their original packaging. Detective Stoyak did not find any broken locks or a lock with which someone had tampered. Sergeant Matthew Peschke also participated in executing the search warrant and searched EC's room. According to Sergeant Peschke, the paper targets from the range were tacked to the walls, fired shell casings, an array of folding knives, a notebook containing detailed drawings of weapons, and the feces of a small animal were on top of the nightstand. All right, so that's the background, everybody. Again, this is the Court of Appeals decision on whether or not the parents can go forward on a trial. So next we're into Part B, the trial court proceedings. Felony complaints against defendants were issued soon after their arrest, both of which alleged the defendant's grossly negligent conduct caused the deaths of 4 victims by storing his or her firearm and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent failure to perform the following legal duty, to wit: failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others, or from so conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and opportunity to do so. So that's the legal standard. After the conclusion of the 2-day preliminary examination, the district court provided its decision to bind over defendants as charged. Citing the head case, the district court articulated its reasons for doing so. Therefore, in this case, after hearing extensive evidence, extensive testimony, as well as evidence in reviewing and viewing extensive exhibits, the court finds that the deaths of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in their care of their son. Specifically, the court finds that the prosecutor has shown by probable cause standard that one of the defendants' son presented a danger to the community. Number 2, that the danger was apparent to an ordinary mind. Number 3, that the defendants, James and Jennifer Crumbley, neglected to diligently address and or divert that danger. And number 4, that the danger resulted in the 4 deaths of the young children at Oxford High School. There was extensive testimony that E.C. was certainly a troubled young man and that the defendant had knowledge of that situation, but they purchased a gun which he believed was his and that he was free to use. Therefore, the court is binding the defendants over as charged. Before the circuit court, defendants filed a combined motion to quash the bind-over, contending that the district court abused its discretion by finding probable cause existed to believe defendants committed involuntary manslaughter. In particular, defendants argued that the bind-over had to be quashed because, as a matter of law, the prosecution could not prove causation. Though acknowledging that the issue of proximate causation as opposed to causation in fact hinged on whether E.C.'s independent criminal actions were reasonably foreseeable, defendants argued that the district court's reliance on the head case up here, and its ultimate conclusion were in error. The circuit court issued an opinion and order denying the motion to quash, explaining why it could not accept defendants' causation argument. The court concludes that sufficient evidence has been presented to allow a reasonable juror to find factual causation and to allow a reasonable juror to conclude that the deaths of the victims were a direct and natural result of the defendants' gross negligence. The court further concludes that the criminal misconduct of the defendant's son was an intervening cause, but that a reasonable juror could conclude that his actions were reasonably foreseeable. Therefore, a causal link between defendants' actions and their liability for the deaths of the victims, as alleged by the people, is not severed by the actions of their son. A reasonable juror could conclude that the action of the defendant's son was related link in the causal chain. Because the circuit court concluded that the district court did not abuse its discretion in binding over defendants as charged, it entered an order denying the motion to quash. All right, so that takes us through the legal standard in the background. Now we go into the analysis. And this is where the court is going to set out that probable cause issue going on and whether or not the gross negligence rises to that level. A standard of review. As with all issues we address on appeal, the first question we must answer, and often is one of more critical ones, is what standard to apply when reviewing the trial court's decision. Appellate courts utilize varying standards of review, and which are employed depends on the issue raised, legal or factual, and the context in which it arose from a trial motion ruling. De novo review involves no deference to the trial court decision and is usually limited to issues of law. On the other end of the spectrum is the abuse of discretion standard, which grants much deference to the trial court decision. Citing case law here, where we address a circuit court's decision on a motion to quash the bind-over decision made by the district court, there are multiple standards of review. Now, rather than take you through kind of this long detailed road of whether or not to review de novo on this motion to quash the binding. I will fast forward everybody. Again, just a couple of paragraphs until we get to the probable cause standards. So needless to say, this court did find they had jurisdiction to review the case. So let's take a look at the probable cause standards next. In general terms, the purpose of a preliminary examination is to determine whether a crime was committed and whether there is probable cause to believe that the defendant committed it, citing People v. Rogers. Quotation mark citations are omitted here. More specifically, in order to bind a defendant over for trial or to put them over into trial in the circuit court, the district court must find probable cause that the defendant committed a felony based on there being evidence of each element of the crime charged or evidence from which the elements may be inferred. We're citing case law here. Probable cause requires enough evidence to cause a person of ordinary caution and prudence to conscientiously entertain a reasonable belief of the defendant's guilt. So if you are ever wondering what exactly is probable cause, there's the standard right here. All right, it's enough evidence to cause a person of ordinary caution and prudence to conscientiously entertain a reasonable belief of the defendant's guilt. That's probable cause. The district court abuses its discretion by binding over a defendant when the prosecution has failed to present sufficient evidence to support each element of the charged offense. With these standards in mind, we now turn to the narrow issue presented in this appeal: whether the district court abused its discretion in concluding the prosecution presented sufficient evidence to establish probable cause to believe the defendants caused the deaths of the 4 murder victims. See causation. Causation is, of course, an element of involuntary manslaughter. However, the concept of proximate causation is obscure. We are citing understanding criminal law here. Nevertheless, in the criminal law context, the term cause has acquired a unique technical meaning. Specifically, the term and concept have 2 parts: factual causation and proximate causation. Citing case law here. Factual causation exists if a finder of fact determines that but for the defendant's conduct, the result would not have occurred. We refer to this, everybody, as the but-for test. Citing case law here, the existence of factual causation alone, however, will not support the imposition of criminal liability. Proximate causation must also be established. Concerns arise regarding whether the defendant's conduct was the proximate or legal cause of the decedent's death. When the death is so remote from the defendant's conduct that it would be unjust to permit conviction. In other words, proximate causation is a legal construct designed to prevent criminal liability from attaching when the result of the defendant's conduct is viewed as too remote or unnatural. So too many steps are in between the act and the person being accused. Importantly, under the criminal law, there can be more than one cause of harm, and a defendant's acts need only be a contributory cause that was a substantial factor in producing the harm. We call that the substantial factor test. In assessing criminal liability for some harm, it is not necessary that the party convicted of a crime be the sole cause of the harm, only that he be a contributory cause that was a substantial factor in producing the harm. The criminal law does not require that there be one proximate cause of harm found. Quite the contrary, all acts that proximately cause the harm are recognized by the law. For a defendant's conduct to be regarded as the proximate cause, the victim's injury must be a direct and natural result of the defendant's actions. So this is the standard really that they are using when they are applying it to the victims here. Sometimes, as in this case, when there may be more than one potential cause of harm to the victim, it is necessary to examine whether there was an intervening cause that superseded the defendant's conduct, such that the causal link between the defendant's conduct and the victim's injury was broken. If the finder of fact determines that an intervening cause supersedes a defendant's conduct such that a causal link between the defendant's conduct and the victim's injury was broken, proximate cause is lacking the criminal liability, and criminal liability cannot be imposed. Whether an intervening cause supersedes a defendant's conduct is a question of reasonable foreseeability. So these are very technical legal terms that we're dealing with here. Ordinary negligence is considered reasonably foreseeable, and it is thus not a superseding cause that would sever proximate causation. On the other hand, an act of God or the gross negligence or intentional misconduct by the victim or a third party will generally be considered a superseding cause. So something like a lightning strike, something like that. Nevertheless, the linchpin in the superseding cause analysis is whether the intervening cause was foreseeable, based on an objective standard of reasonableness. If it was reasonably foreseeable, then the defendant's conduct will be considered a proximate cause. If, however, the intervening act by the victim or the third party was not reasonably foreseeable, gross negligence or intentional misconduct, then generally the causal link is severed, and the defendant's conduct is not regarded as a proximate cause of the victim's injury or death. So all of this is a causation analysis, everyone. And I will go into that later once I turn comments on. So let's take a look at factual causation. We quickly dispatch with any argument that factual causation did not exist. Factual causation is relatively easy to establish. So again, this entire analysis is the court trying to figure out if these parents caused the homicide of these 4 victims. Reversed in part here. So the record squarely supports that but for the defendant's acts or omissions, EC would not have killed the victims that day. On the basis of the evidence presented at the preliminary exam, a reasonable fact finder could conclude that EC would not have been able to shoot and kill 4 students but for the defendant's decision to purchase their mentally disturbed son a weapon. Their failure to properly secure the weapon, and most importantly, their refusal to remove EC from school when he made overt threats to hurt other people. But for the defendant's informed decision to leave EC at school, these murders would not have occurred that day. So again, this is that but-for standard. Proximate cause. Subsequent to the trial court denying defendant's motions to quash, EC pleaded guilty to 4 counts of first-degree premeditated murder. While there was no dispute during the trial court proceedings that EC's actions were intentional, his guilty plea to first-degree premeditated murder cement that fact. And we have footnote 11. For this reason, the court's decision in the Head case, so the previous case, which involved the foreseeability of an accidental shooting, is not helpful. An accidental shooting, i.e. negligence, is normally foreseeable, whereas intentional acts like that involved here are not. But was EC's intentional misconduct an intervening cause that superseded defendant's actions, such that the causal link between the defendant's conduct and the victim's injury was broken, and proximate causes lacking in criminal liability cannot be imposed? Defendants contend that the answer is yes, as they see firm statements in both Schaefer and the Fiesel cases to the effect that intervening gross negligence or intentional misconduct of a third party must always be a superseding cause. But, as with many things in life, this rule is not black and white, as defendants suggest. Indeed, while the Schaefer court may have used expansive language while discussing a specific example, it made clear that the linchpin in the superseding cause analysis is whether the intervening cause was foreseeable based on an objective standard of reasonableness. Even when articulating the causal chain, even when articulating the general rule that the intentional misconduct on the part of the victim is considered sufficient to break the causal chain between the defendant and the victim, the court notes that this is only because the intentional misconduct is not reasonably foreseeable. And then we're citing the Fiesel case. Here, EC's intentional misconduct did not, as a matter of law, supersede defendant's acts because a cause of the victim's deaths, as his acts will only supersede defendant's acts if his intentional acts were not reasonably foreseeable, which of course is generally the case. Turning now to the district court's proximate cause determination. The relevant facts revealed that prior to arriving at the school on November 30th, so this is really the crux of the case, everybody. There's only a couple pages left to this opinion, and then I will turn comments on. But understanding this analysis will help you walk through how the jury will have to walk through their decision as well. Turning now to the district court's proximate cause determination, the relevant facts revealed that prior to arriving at the school on November 30th of 2021, defendants were aware that EC had repeatedly experiencing significant episodes of hallucinations and or extreme paranoia. 2, EC was in a distressed mental state because of the loss of his grandparent and the family dog and the departure of his best friend. 3, EC himself realized his poor mental state such that he requested defendants to help him obtain medical assistance. 4, despite defendants' knowledge of EC's mental state, they purchased him a weapon which was readily accessible to EC. 5, on November 29th, the day before the shootings, EC was researching bullets while in school. And 6, during the first hour of class on November 30th, EC watched a video involving that kind of behavior, and during second hour drew pictures of a bullet, a weapon resembling the one that he had, a person bleeding from bullet holes, and wrote "blood everywhere. The thoughts won't stop. Help me. My life is useless. The world is dead." Defendants were also presented with significant modifications EC made to that worksheet, where he clearly intended to portray a different, happier message about the school and himself. So again, these are the pieces that the jury is having to assess. Despite their knowledge of all of these circumstances, when given the option to help EC and take him out of school, defendants did nothing. They did not, contrary to the recommendations of Hopkins, take EC home and get him immediate medical help. Nor, when they decided to leave him at school, did they tell school officials about EC's history of mental health issues, nor explain to them that EC had access to a weapon similar to the one he drew on the math worksheet. Defendants neither asked EC if he had the weapon with him, nor did they look in his backpack. And when they left the school, defendants did not go home and ensure EC had not taken the weapon. Given all of those facts, it was not an abuse of discretion to conclude that there was probable cause to believe that a juror could conclude that a reasonably foreseeable outcome of defendants' alleged gross negligence was EC committing a shooting that day. One of the few reasonably foreseeable outcomes of failing to secure a firearm that was gifted to EC was that it would be accessible to EC, and that in his mentally deteriorated condition, he might use it in an unlawful way. In light of those foreseeable events, when presented with what he had just drawn, written, and viewed that morning, a reasonable juror could conclude that it was foreseeable that EC possessed his recently gifted item and intended to use it that day. As a result, a reasonable juror could conclude that EC's intervening acts were not a superseding cause of the homicides. In fact, given the uniqueness of the connections between EC and the defendants, we question whether EC's acts are properly considered as intervening causes capable of superseding defendants' criminal responsibility. Indeed, in most cases involving a question of superseding causes, the third party or victim's act has no relation to the defendants. For example, in an early decision from the Supreme Court in the Rockwell case in 1878, the defendant was convicted of manslaughter when he punched the decedent who fell to the ground. After he fell, a horse either jumped or kicked the decedent, killing him. During a second trial, the jury queried whether the defendant could be found guilty if he knocked the decedent down but the horse killed him. The trial court instructed that he could, and the jury convicted. The Supreme Court reversed, holding that there was no connection between the defendant and the horse, such that it was foreseeable that the death would occur. It is impossible to maintain such a charge without making everyone liable not only for the natural and probable consequences, but for all possible consequences and circumstances which immediately follow a wrongful act. There was no necessary connection between the act of the respondent and the conduct of the horse, which he cannot be said from the record to have been responsible for. So, too, it is more recent proximate cause cases. In Schaefer, the alleged intervening cause was at the allegedly negligent designed highway off-ramp, while in the companion case, the large case, the alleged intervening cause was the victim riding a bike in front of the defendant's car. The purported intervening cause in Fiesel was the victim's level of intoxication. In each of these decisions, there was no connection between the defendant and the intervening cause. They were separate and distinct from one another, which naturally led to the argument that the intervening cause was a superseding one. But here, as we have explained, the evidence showed the opposite. Defendant's actions and inactions were inextricably intertwined with EC's actions, with the intervening cause. This connection exists not simply because of the parent-child relationship, but also because of the facts showing the defendant were actively involved in EC's mental state, remaining untreated, and that they provided him with a weapon used to kill the victims, and that they refused to remove him from the situation that led directly to the shooting. In this circumstance, a reasonable juror could conclude the defendant's conduct increased the foreseeable risk of a particular harm occurring through a second actor, and that what EC did at Oxford High School that day was foreseeable. Then we have footnote 12. We acknowledge defendants' argument that no parent could reasonably foresee their child committing a mass shooting, but these issues are based on facts and what is reasonably foreseeable under an objective standard, and that the circumstances defendants are presented with on November 30th of 2021 provided a heightened set of warnings that could lead a jury to find causation. Additionally, with respect to foreseeability, more relevant than the number of people shot is the foreseeability that EC would shoot someone that day. Finally, we share defendants' concern about the potential for this decision to be applied in the future to parents whose situation vis-a-vis their child's intentional conduct is not as closely tied together, and or the warning signs and evidence were not as substantial as they are here. But those concerns are significantly diminished by several well-established principles. First, the principle that grossly negligent or intentional acts are generally superseding causes remains intact. We simply hold that these unique facts, and in this procedural posture and applicable standard of review, this case falls outside the general rule regarding intentional acts because EC's acts were reasonably foreseeable, and that this is the ultimate test that must be applied. And we have footnote 13. Much like in Rideout, where the Supreme Court held the reasonable jury could find the decedent's decision to leave the area of safety after defendant's conduct, which generally acts as a superseding cause, was foreseeable given the circumstances. Second, our decision is based solely on the record evidence and the action and inaction taken by the defendant, despite the uniquely troubling facts of which they were fully aware. And this point is important, as although the judiciary typically recognizes that a decision's precedent is limited by the facts at issue, it is particularly true when the court expresses that limitation, citing multiple cases. And third, our decision is premised upon a differential standard of review and is based only upon the record established at the preliminary exam. Whether a jury actually finds that causation has been proven after a full trial, where the record will almost surely be more expansive, including evidence produced by defendants, is an issue separate from what we decide today. The district court did not abuse its discretion in determining EC's decision to shoot 4 classmates was not a superseding cause because it was foreseeable based on an objective standard of reasonableness. The circuit court's order is therefore affirmed. And then we do have one last footnote for 14. Defendant's reliance on People v. Zach is misplaced. Although Zach held that providing a weapon and opportunity for another to kill was an intervening cause of death, That was not reasonably foreseeable. Our facts are quite different. Not only did defendant gift the gun to EC and allow him to stay in school, there was a significant evidence that he was intending to use that gun to harm someone. So with that, everyone, I will go ahead and turn on comments so we can talk about this case. Here again, we are dealing with this particular case. Oh, thank you, VC. Thank you. Oh, there we go. Thank you. Appreciate that. Appreciate it. Well, welcome in, everybody. Hello. Good evening. Good evening. Hello. 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 Yes. Very interesting. Yes. Thank you so much, VC. Thank you. This is a very interesting case, everybody. Very interesting. Now, as you know, we have had Jennifer was on trial here. The jury is out. Thanks for covering this. I've been following it closely. Yes, well, it's a really difficult case. Will the jury be made aware of this decision? So, great question, Larry. So, the jury instructions will have all been pre-approved by both sides, and they have to be within compliance of any prior decision, but they wouldn't be told about it. So it wouldn't be that clear. It's heartbreaking on so many levels. It really is. It really is. After watching trial, I agree. They should be held accountable. Yeah, well, this particular set of facts, and I think the court was really specific here and said, look, we're not trying to open the door to, a whole new world. But with these kinds of facts, yeah, I think we've got a good question in front of the jury. Very sad case overall, absolutely. Red flags, yes. Well, and there were a lot of red flags, everybody. And so, I did take some time and I watched her direct examination, which I thought Jennifer did an amazing job on direct. And she did a great job on cross, too. And, her entire thing was, I really had no idea. I had no idea. My husband was the one that wanted to get the weapon. My husband was in charge of putting it away. He was the one. And that's what's so brilliant about splitting these two cases. So originally, these two were supposed to be tried together. But when you split a criminal case like this, each one can blame the other, and the jury will have no idea what the other jury has. So she's going to put all the blame on him, and he's going to put all the blame back on her. And so that's a brilliant strategy. He was all but screaming for help. Well, and there was a lot of information that came out during cross, too, about the amount of time that they had these horses and the amount of money they spent on the horses and how the parents were really never there. They were working or doing their own thing. And they really didn't spend very much time together. So there is some talk of that, but how that affects a person, a child, who's 15, 16 years old, that's an important question because we do have some neglect issues, right? Neglect is a crime if you neglect your child. And in here, they're talking about gross negligence. They neglected him to a point where it was just off the charts. He was 15 originally, and then bumped up to, so when this all started, I think he was 16 total. So this is him here. Neglect is not a crime. Now, neglect can be. Neglect of a dependent. Neglect of a dependent is a crime that can be charged. Did not think through their actions. Yeah, I agree. It's such a critical age. It is, but this is a tough question, though, everybody. This is, one of the questions that when I was prosecuting cases, one of the big questions was, what do we do for the parents who say For example, let's just take whether or not a kid goes to school. So the parents get up, they get their high school kid up, and they're like, you need to go to school, you need to go to school. Then the parents go to work, and the high school kid decides to stay home. Like, what are the parents supposed to do about that? What level of responsibility do the parents have? I mean, something innocuous, like, actually going to school, not something at this level. But that poses that question, though, right? Of how much responsibility do parents have over their kids when they're at this age? So I'm not describing. Yes. Yeah. I mean, in this particular case, there were so many, I think somebody already said red flags. I think that's an exceptional way of putting it. He's their son. It's both responsibility. True. We'll see, David, it seems so simple. Like I myself can't understand why this situation, there's a lot going on. We've lost a grandparent, we've lost a friend, we've lost a dog. There was like according to her testimony, there was some kind of like a Black Friday special where the dad and the kid went off and bought this weapon together. That is something that is just really suspicious to me. The school's going to contact you long before it gets to this level. Well, Kristen, that's exactly what the defense was putting on for Jennifer. The defense was saying, I had no idea. Why didn't you guys check his bag? Why didn't you guys tell me he needed to go? She testified that when they had that meeting with the school officials, nobody said he needed to go home. And they all agreed that he does better when he's around people. And if he went home, he would just be sitting there alone by himself because these two were at work. And the counselor was like, I don't want him sitting at home by himself with this kind of ideology or ideation going on. It's not going to be safe, so he needs to stay at school. So she testified to that as well. Defense is trying to blame the school. Yes. Blame the school and blame the dad. That's what they're trying to do. But mother took EC to the shooting range. True, Dolores, true. And EC was showing her how to use the weapon. I'm not sure about anybody else, but if my teenage kid is showing me how to use a weapon, I think the roles are reversed. I think it's reversed. Has anyone sued the school? Well, not at this point. Not yet. Not yet. Yeah, not yet at this point. Both parents are. The defense attorney. Well, now, Steffi, that's another thing, everyone. Let's talk about the defense attorney. Has anyone heard about this defense attorney? There's been had all the information the school didn't. True. They did, but they didn't have, apparently they hadn't looked through his journal. They didn't look through his backpack. They didn't look through his phone. They didn't look through his social media. All of those things. And meanwhile, the school is saying, well, we can't look through that stuff. We didn't have enough suspicion yet. Okay, you've got videos. All right. So yes, frowny face. So this is the attorney. And this woman's gotten a lot of flack. All right. She's got her leaning tower of Pisa here, which quite frankly, this is exactly how my trial table looked when I was doing cases, everybody. All right. I'm going to confess right now. This is exactly what it looked like. Although they were in boxes and they were on the floor. But this I think really shows how human we are, because she was making all kinds of comments that were like, wow, did you really just say that? And she was kind of talking back a little bit to the judge, and she was like trying to order clothes, and she seemed like just really all over the place. But yet when she was doing her direct examination, it was perfect. Her direct examination was perfect. When she had to clean up cross-examination of her own client, she did an amazing job. But yet, when the jury instructions were being questioned, she didn't push her questions hard enough. She had a valid question, actually. She had a valid point, but didn't push it hard enough. So there's good and there's bad. Yes, my DMs are open here. There's good and bad, but at the end of the day, she's very, very human. Yes, I believe she's trying to order tank tops at one point. Lived in our neighborhood. Nice family. Really? Oh, weird. Oh, I bet it is. I bet. So yeah, I mean, I think that there are definitely some pieces where you're like, what is she doing? But if you were just going to read the record, like if you weren't watching these things, these extraneous things, if you were just reading the transcripts, her questions were well organized. They were not all over the place. If anything, I thought the prosecution's questions were all over the place, where they just threw it out a fan and it just spit everything out all over the place. But she was very organized in how she presented her questions. But yet she had some other pieces that I thought were totally inappropriate when she was dealing with it. All right, so the jury has not come back. My understanding is they've let the jury go for the day. Now, this morning, they did the jury instructions and then sent the jury out. And the jury came back about 2 hours later, I think, and they had a question. And they had a question on this idea, again, of the prosecutors trying to say, was it gross negligence at that level, or was it, a different kind of negligence? So they had two different types of negligence they were going down. And the jury's question was, can we answer yes to both or no to both, or can it be one or the other? So they had a question regarding the actual definition. So that question did go back to the jury this morning, and then they deliberated, but they were let go for the evening. They thought he would only hurt himself. Does that mean two legal requirements? That's a great question, Jennifer. And that was one of the things that the mom said, was she was worried that he, as she had heard it, anybody that does this kind of an offense turns the weapon on themselves. And so that's why she texted, don't do it. And she was afraid he was going to harm himself. But yeah, does that meet with the level of they would have known that he would have harmed someone? So that would meet the level of negligence. Was it ill to have the gun unlocked? Well, that's another great question. She's blaming the husband. She's saying the husband was in charge of having the lock on the weapon and having the weapon hid away. She said he hid it in various places around the bedroom. Meanwhile, she was the one that had the ammunition, and she was in charge of hiding the ammunition. Is the boy getting psych help? Well, he's life without parole, so probably not. Our prison systems aren't exactly good at helping with psychological issues. Still neglect. Yeah, I think so. The parents will throw one another under the bus. Absolutely. They'll throw one another under the bus, and because they're being tried separately, they can do that because they'll have two separate juries. So her jury will say, oh my gosh, it's totally, if they wanted to, they could say it's totally the husband's fault. Meanwhile, his jury could be like, it's totally the wife's fault. So they can, blame each other, and there's no way those juries are going to talk to each other. We used to have mental health hospitals. I know. And then they'll both throw the school under as well. But the testimony being offered by the school is just top notch. And this is where the juries come in as our fact finder. They come in and they have to say, who do we believe? We believe the investigators, we believe the teachers and the counselors at the school, and their testimony is all very trustworthy. Or do we believe, that the mom had absolutely no idea? And if she had absolutely no idea, should she have? Should she have had some idea that this was percolating, that this was a possibility? It's a good question. Didn't have to be locked legally, then it's more complicated. That I don't know. We're in Michigan, everybody. So her testimony said, you lock the gun because that's what you're supposed to do. But whether or not that's the legal standard, I don't know. She texted him, don't do it, means she knew something was wrong. Well, when she said don't do it, she testified that she wrote that because she was afraid he was going to harm himself. That's her testimony. Like, do we believe her? Do we not believe her? I don't know. Parents were spaced out. No, it's not the law at the time. Okay, fair enough, Lisa. Yeah, I really don't know in Michigan. I'm not exactly sure what the rules are. My goodness, her appearance has changed so much from... Yes, it really has. I mean, this is a very current picture, but she does look a lot different. And, that's going to happen. I mean, the situation's pretty awful. when hiding the gun, when hiding the bullets make me think they were hiding it from the sun. Well, yeah, I think so. People blame others and not taking responsibility. Yes, I agree too. I mean, whose responsibility is it? Whose responsibility was this boy? First of all, he has to own what he did. And because of what he did, he is life in prison, no parole. All right, so he has owned it. He's the only one that's taken any responsibility. So now who else is responsible? Should the parents have known better, when they bought the weapon? Is it all about the weapon? Should they have seen the signs? What about the school? Did they not have proper safety measures in place? Who else is liable? That's the huge questions. In Michigan, they love their pew-pews. They do. He pled guilty. Yeah. So with these, they did go, they ran. And there's a lot of side stuff going on. There's a lot of, kinky business going on with these two for sure. But this kid, he knew he would spend the rest of his life in prison. That was one of the things that he wrote about, was in his journal, he was like, I'm going to spend the rest of my life in prison. So that was part of it. But why did they? Because he wanted it. He wanted it. It was a Christmas present. It was a Christmas present. Yeah, I know. I got to be careful about his face. He wanted to be famous and be seen, perhaps. Yes, Duke, I think that is the legal term, actually. Yes, that's the legal term. Oh my gosh. The default code. Yes. There's so much. There's just so much to what's going on here. There's just a lot of layers. What do you think about defense's closing argument? So I've waited to hear the closing arguments. For me, I wanted to hear the testimony because I find that the attorneys, their arguments aren't evidence. And so for me, before I came on tonight, I didn't want to be too persuaded one way or the other. So I'll have to take a look at it and then make my decisions. At that point, I've kind of reserved it. But yeah, I mean, again, I don't know. He's saying, they didn't pay attention to me. They were off with their own life. They had these horses that they're taking care of. And the dad's driving for DoorDash, which, by the way, there's nothing wrong with driving for DoorDash, but I'm not sure that can support, horses and, a full life. I'm just saying it could support his own life, but could it support, his child and the wife? And then the wife is working too, which is great, but can that help support the whole family and the horses? What are we doing here? Yes, there were other weapons. There were other weapons in the safe. Yep. They were living separate lives. Yeah, I agree. No, I did not see the opening. I have not listened to any of the persuasive arguments. Yes, I will definitely listen to those. They're extremely expensive and high maintenance. Oh my gosh. Well, and it was very interesting too. I thought the prosecutor did an amazing job during the cross, where he was saying, well, what other kinds of hobbies do you have that are extremely expensive, that costs all this money? Because he had crunched the numbers and it was like $25,000 a year on the horses. It was a lot. She referred to Taylor Swift in her opening. Oh my gosh. Can one parent be held 50% negligent and given a day in 10 years and the other 35? Well, what's going to happen, everybody, because they had it split, because they were able to split, each one will be its own entity. So each jury will be able to assess however much responsibility. So technically, the entire 100% of fault, each one of them could have. They could be a finding of 200% fault, technically, because we are in a situation where we have separate juries. So this jury can say, as long as we believe she was grossly negligent, then she's guilty, as well as him. The percentage that they attach to the other side won't have an effect like it would in the civil case. And it's because they're being tried separate. So we start at 0. Her attorney's like, Sally Fields, oh my gosh, you're guessing that's what'll happen. We'll see. Her attorney looks like she's in trouble. I think her attorney looks really exhausted. I mean, this woman's tired. This is a tired woman. Oh my gosh. I'm wondering if she was court appointed too. I don't know about that. I find, well, and I think, Lisa, this is one of those really tough cases. I think if we were sitting on the jury, we would have a different perspective because we would be seeing all of the exhibits. Like here we have a couple we can take a look at and hearing all of the testimony that's, there's no breaks in it. So we would see all of the exhibits, all of the testimony in order, and that would be the only way to have a full view of it. She was professionally hired. Okay. This, she may need to take a break after this. Yes, it's on Court TV. Yep. They paid a fortune for their attorneys and left him with, well, that's why I was wondering if they were public defenders, because I thought his was a public defender. Oh my gosh. Yeah. It seems to me from the testimony I've heard that the child here, again, 15, 16, 17, child, technically the minor, was really kind of a second thought. It was just kind of like, we got to take care of this situation. The evidence, James knew of the son's problems. So there was evidence just saying that just the phone calls and the texts that were between the others was the only evidence presented in this trial. When he goes on trial, that's when we'll start to see the other story kind of unfold. Young man, not a child. Yeah, agreed. I agree. Larry Nasser's. Really? Oh, that's interesting. Oh, I didn't know that. Yeah, public defenders overworked, underwhelmed. I agree. They're really they're the hardest working attorneys. What was the jury's question? So the jury question, from what I can understand, everybody, and again, I didn't hear the exact question. I only heard the attorneys argue and the judge facilitate the answer. So my understanding from what the jury was asking was the prosecution was offering 2 different levels of negligence. And they were saying, can we only find one, or can we find both, or can we find neither? And, are they mutually exclusive, these 2 different levels of negligence? And for me, that gave me the feeling that the jury had found negligence on both of them. It was like, wait a minute, can we find 2? So that's the impression I got. But what happened to the male attorney on the defense? He was there a few days and then gone. That I don't know. I don't know on that one either. I don't know. Yeah, I think he's the one that did the cross. There was a male attorney, a female attorney, then another male attorney that was sitting there. Why didn't the shooter testify? That's a great question, Suze. But I'm not sure that he would help her case. I do not think he would help the case at all. Because if he would testify, what would he testify to? That his mom wasn't there, and that he felt alone, and she didn't care. So I think it would be very detrimental to their particular case. Was going to plead the 5th. Okay, well, that's fair, although I'm not sure why. If he's already in prison forever, so I don't know, but fair enough. His journal was enough. Yeah, his journal was very damaging. And they had law enforcement read, I think it was law enforcement that read the journal. Seems like the parents ignored him. Yeah, I think so. And, it makes you stop and think for a minute, of how much everybody is just racing around, and what's getting forgotten, what's getting lost. And I know that's the question we all have to ask ourselves. What's getting neglected? What's getting put on the back burner? But if the thing on the back burner is your child, you're in a bit of a pickle. Like, that's kind of the question. Is he in an adult facility? Great question. I'm not sure. I'm not sure if he's in a juvenile facility and then once he's 18, then he'll get transferred or not. Or not. Watch my kid's emotional state. Yeah. Well, and she testified that she was like she's a helicopter parent, that she was very involved in his life and all of those things, which is really interesting. I'm a lawyer that makes mistakes. That's a true story. That's true. Every parent needs to watch themselves and everything. Yeah, I know. It's tough. It's a tough situation. Like we don't, yes, the jury is still deliberating. Like, again, we can't blame parents for every single thing, especially when you have a high school kid, a high school young person involved. But on the other hand, where is the line? Where is the line between negligence that results in homicide and understandable parenting? That's kind of what this case is about. Where is that line? He's in, youth offenders currently. Yeah, he would be transferred. In your professional opinion, what do you think the verdict will be? I think she'll be found guilty. Yeah, I do. For homicides, I think she'll be found guilty, and I say that based off of the jury's question that came out. Usually it's a 50-50 coin toss, but if the jury's asking questions, sometimes you can kind of feel it out. But that's my guess. Yeah. And I mean, if she bought it or the husband bought it, whomever, it was, equal responsibility. There were two parents here, and, she could have said no, I suppose. I mean, I don't know what all the dynamics are here for everything, but I mean, they both need 100% of liability for what their child does. Husband bought and signed saying he wasn't giving it to anyone. That's another good point, Issa. That's a really good point. Because he signed the paperwork saying, it's illegal if you give this to someone else. Securing it. Yeah, I agree. What question did the jury ask? So the jury was asking about levels of, wait a minute, I just lost it. Everybody, it just flew out of my head. Negligence. So there were a couple of different levels of negligence that the prosecution was asking or was going down. They presented a couple levels. So there was gross negligence and then one other kind of negligence. I cannot remember. And so they were asking if they could say yes to both, or if they could only say yes to one, or no, or whatever. And so the question was, yes, you can say yes to all kinds. There can be multiple different kinds of negligence. So that's kind of what leads me to believe that they're going to find her guilty. But that's just each count had both. Yeah, exactly. That's why I'm leaning that way. What would her prison be? Now that I don't know. I would say, it's involuntary manslaughter. So, usually we've got, let's just take a homicide. So usually we have, so murder is going to be your class A, and then second degree murder, or second degree, nobody really knows what second degree is. Second degree is just everything that's not murder. All right, so these are our murders. And then we have felony murder up here as well. All right, so felony murder. So those are usually our class A's. So that's where you get life, forever, or your life is ended. Then after that, we get into the manslaughter, and we have two types of manslaughter. We have involuntary manslaughter, and then we have voluntary manslaughter. And both of these have to do with the intent level. So the intent, so what level of recklessness is involved, what level of knowingly is involved, that will make the a determination on which level of manslaughter. So involuntary or voluntary manslaughter, you're looking at probably, you could have a B or a C, even sometimes a D felony. So a B felony would be 20 years, a C felony would be 10 years, a D felony would be 5 years or more. All right, so I'm breaking it down for you here, everybody. That's your voluntary. Involuntary, the highest you're going to be looking at for an involuntary is probably going to be a D, which is going to be a 5 year. So we're looking at voluntary for them. So actually, it looks like they're both at involuntary. Involuntary manslaughter, 2 counts, and they're charged at an F. And so I'm not sure exactly what an F would be because my state only goes to D, but it's going to be a lower level. So it's probably going to be 5 to 10 per count. So there you go. 60 years for 4 counts. Okay. Could be, yeah. Times it times 4. Yeah. So again, this is just a wild guess. I'm not in Michigan. I'm not in Michigan here, people. But if she's got involuntary manslaughter for both of those, that's the lowest level of homicide. Mathing. How do they make them concurrent or consecutive? It's up to the judge. It's up to the judge. A lot of times. Oh, look here, everybody. Sorry about that. We still have involuntary, and another one here. We've got, yeah, see, with it charged at a level F, I don't see how it's going to be more than 5 to 10 years. I don't see how they're going to be looking at more than 40. So, I mean, I'm just guessing here, unless for some reason F goes up to 15. Because you start with an A, and your A is life. So, yeah. But anyway, the judge will make the decision. The judge will decide, do we have a situation where there's remorse? Do we have a situation where it's going to happen again? Do we need a deterrent? Do we need rehabilitation? Do we need to keep her away from society? So she'll take a look at all of those. And they consider time served? Yes, they do. But it's going to be pennies at this point, even though time served in county is a lot worse than time served in state. Did they have other children? Nope, only one. Did they have to prove that they knew he would do this? Max is 4 years. Okay, thank you, Sarah. Whew, I was sweating on that one. All right, 4 years. I was going to say, I don't think it's going to be more than 10. All right. So county lockup is awful, VC. Oh, it really is. It really is. So if they do it consecutively, again, it's going to be because the judge feels that amount of time is the most appropriate. So she needs to be out of society for that period of time. She needs to, for whatever. A lot of times in homicide cases, because there has been a homicide, a lot of times they'll run those consecutively. So she'll spend a couple of years. Yeah, but I mean, it's her record. Like, her life is over. This woman's life is over. It's now, as she even said when she was testifying, it's not over like the victims' lives are over, but it is essentially over. Her life is destroyed. Up to 4 years per. Yeah. Yep. That sounds right. Yeah, I had put it at 5. Again, in my jurisdiction, a D level is 5. So I guess they have an E and an F. We don't have E's and F's in my jurisdiction. Oh my gosh. 4 per charge, yes. 4 years max. Exactly, Sarah. Yes. 16. What about the dad? He's charged at the same level. They're charged with the exact same thing. So he's also charged with 4 counts of involuntary manslaughter. And again, the reason why this is involuntary is because it's negligence. All right. So there's this negligence is what bumps it to involuntary rather than voluntary. All right. So that level. If she's convicted, basically he is too. Well, we don't know. We don't know, because they have split the trial, because they've split, each one will be its own world. So if they were tried together and they tried to kind of point the fingers at each other, that would be different. But it starts at 0 again. We completely start at 0. When she's done, she's off. And then the next one will start at 0. So we will have a full trial again. He has it worse, I think. Well, he's the one that signed the paperwork for the weapon. Maybe he has a better lawyer. That's a good question. That's a good question. If mom's found guilty, will the dad get a plea deal? That's a great question. He may want to plead out. But I'm not sure what you could plead. I can't figure out how you would go lower than involuntary when there's a homicide involved. Involuntary manslaughter is the lowest level of homicide. That is the lowest. So the only way that you would get anything less than that, if you wanted to do a misdemeanor, which you could plead out, but you're not going to be able to pull a misdemeanor out when there's been a homicide. So involuntary really is the lowest level. I'm not sure how he would plead. Reckless endangerment. Well, maybe, but it'd be reckless endangerment resulting in death, which would be involuntary. He purchased the weapon on a Black Friday. Yes, I know. But yeah, the reckless endangerment element is very important because, again, the recklessness is the intent level. So that's the intent. Irresponsible. Yeah, I agree. Zero emotional support. Yeah, there was something missing for sure. There were a lot of things that, again, what the judge was talking about when he was going through, actually, I don't know if it's a man or a woman, but when Judge Murray was going through, they were talking about these different tests that we use in civil litigation when we're dealing with causation. One is the but-for test. But for his dad purchasing the gun, 4 people would not have passed away. Also, substantial factor is another test that we use, meaning that it played a substantial role. So it was like the key piece to it. Is it a crime to purchase a weapon for a 15-year-old? That's a great question. And in Michigan, I don't know how old you are supposed to be. My understanding is you've got to be 18 or 21. I don't even know if you can be 18. I think 18 only has certain kinds of weapons. Like you have to be 21 in order to have certain other kinds of weapons. That I don't have full knowledge on, but if you're a minor, I don't believe it's allowable. And again, the dad bought it for himself. Technically, under how he wrote out and signed the contract, he bought it for himself. 21? Okay, each state's different. Yeah, that's what I'm wondering. What about the loved ones? Yeah, that's a great question, Katrina. And I mean, what kind of justice is there? What could possibly, be enough to satisfy, the accountability level for this situation? I just don't even know. It's so sad. I thought it was 21. I think it's 21 for certain kinds of weapons, but because I'm pretty sure there are certain hunting weapons and various other kinds of weapons that you can get when you are 18. 21 is a national requirement for a hand one. Okay, thanks, Thomas. Perfect. Thank you, Thomas. That's what I was wondering. Yeah, because I think there are other types that you can get if you're younger. Because, you have to be able to handle certain kinds of weapons if you're 18 and in the Army, right? I mean, you're not dealing with certain other kinds of weapons. Mm-hmm. Pistols 21, a rifle's 18. Okay, thank you. Okay, yeah, that's what I was wondering. Although there's a bit of a kick to that. Watch out for the kick. Yikes. Yeah, exactly. In Georgia, you can have well, I mean, it's different. Everybody's different. Have a good night. Yes, thanks for coming by. It's always wonderful to have you. Appreciate it. It takes someone's Well, right. That's a good point, Katrina. That's a very good point. And that's where we're at here. Not only, the thing is, he did have multiple weapons, but only the one that they apparently got for the kid was the one that was used. Is the lawyer, and I don't know. I don't know. She shouldn't have been transporting it unless she had. Oh, that's an interesting point. Actually, that's a very interesting point. Mm-hmm. You have to own. Well, I mean, I don't know. Personally, I'm more of a bat person, but I can understand if you're out in the sticks. I mean, I get it. I'm not gonna. I can't place a judgment down on that. I'm just, pro following the rules. Like, follow the rules. Why didn't they plea and ask for a reduced sentence? I don't know. I really don't know. I think it's because it's kind of a tough question. It's a tough question. And she chose to testify. We're not in a self-defense case, but she chose to testify, which is just blows my mind. And she did an amazing job, in my opinion. She did a really good job. I'm a bat person. I'm a bat person, but I'll also, if fire's needed, then we'll bring it out. But, oh my gosh. Did they come to yeah, the verdict's not been announced yet. They've left for the day. But she testified and gave her side of the story where she was saying, I thought my kid and I had a good relationship. I thought we were okay. I thought everything was fine. He was a little down, but I didn't think it was a big problem. And she was very believable. She was very believable. And she did a great job on cross too, I thought. But that will be very interesting. I think that was helpful for her. And I normally would not say that when a defendant testifies on their own behalf. I normally do not recommend that. She sounded believable. She did. It sounded like you could. Exactly. She wouldn't change anything. Yeah, but I mean, that's a tough one because what do you say? Like, oh, I wish I could have paid more attention to my kid, because then you're acknowledging you neglected your kid, right? So she's got to say, I wouldn't do anything different by saying, like, I did everything I could. I couldn't have done anything different. So you can't find me negligent because I did everything I could. I prefer other options. Well, yeah, I mean, it's nice to have options. I think less lethal options are always good to have. I think multiple options is an excellent way of saying it. Excellent way of saying that. She did not see the signs. Right. She didn't. And that's the question though. What if parents miss the signs? What if they miss the signs? How much responsibility do parents have? And then because they missed the signs, 4 people died. So, I mean, that's a lot. That's a pretty big. She was preoccupied. She certainly was. Yeah, Katrina, one of the things that I had a trainer tell me was you have to, if you're going to have a weapon like that, you have to be willing to use it. And, I think that's something that you really have to accept. The judge sent 3 jurors home sequestered. Is that normal? Yeah, absolutely. And it's interesting here too, because they've got 17. So they have actual 5 alternates. So they've got plenty, if anything happens, they've got plenty of backups. Brought this human into the world, better do your job. Well, I can't help but remember, was it just me, everybody, or did you have a parent that say, if you do anything that makes me have to go to jail, I'm coming for you? I don't know, maybe it was just me. Sorry, Mom. But, I knew from a small age that if you screw up, your parents are going to pay for it. I just thought that was a given. I thought everybody knew that. So, if you get your parents into trouble, you're in big trouble. It's the way we grew up. Oh my gosh. Can't blame everything on others. True, exactly. It's not that way anymore, Kristen. No. Do alternates sit on everything? Yes, yes, they sit on everything except for the deliberations. So when the jury, the actual final 12 are deliberating, then the alternates will be in a different room. They won't be deliberating, but they will be, they've heard everything and seen everything, so they can get pulled in if it needs to be. My parents said I'd be better off in jail. No, oh, no. How long will the jury take? Oh, there's no way to know. There's really no way to know. And this is a tough case, too. So, education about gun use. I agree, Katrina. I think that that's very important. I mean, that's how you, for anything, you get basic safety rules when you're in wood shop class, right? Or when you're fixing an engine, you got to have your basics. So why not when you have something that is of that caliber as well, so to speak. So I'm a big fan of that. Jury duty with James. No, I've not. I think the school's more to blame in regards to the actual event. I think you've got a good point. Because the school is saying, well, we tried to tell you, but then the school's also saying, well, we didn't think you needed to go home. But then what signs should the school look for? At what point do the schools say you are an absolute danger? I mean, I have just down the road from me is our high school, and there is swatting going on left and right. And it's like constantly everyone's like swatting all the time. And so the question becomes like, well, where's the line between we are trying to like give these kids an education and also we have to make sure everything's safe. So where is that line? I just don't even know. I have no idea. But I'm not sure what kind of training they have to assess that either. Isn't the school responsible for raising? Oh, I don't know. Yeah, the swatting just means that people are calling in threats when there aren't any threats, and it causes all of the squads to come out. Yeah, perfect, Katrina. That's exactly right. Start showing the grisly details. Yeah. I mean, responsible ownership is the key here. You gotta have responsible ownership. I would not go to jail for them, but if you do the crime, you do the crime. You do the time. True story. Yeah, exactly. Exactly. True. You try to hold kids responsible. Frank, that seems to be one of the a huge issue right now, isn't it? I mean, it really is a huge issue. Like we got into this phase where parents became overprotective, and then like I've seen parents fighting teachers. I'm like, when did that happen? When did the parents start fighting the teachers? Like, dang. I'm like, here, take my kid. Thank you. Thank you for taking my kid. Please, no, I don't need him back. Just here you go. Like, it's a lot. It's a lot. And teachers are, they're not paid enough to deal with that. These parents, oh my gosh, it's a lot. It's a lot. It's hard to watch. Live stream on Thursday. Yes, I agree. Yep, that'll happen. It's not the school's responsibility to raise your kid. Absolutely, Kristen. I agree. It's not the school's responsibility. And the fact that they take your child for so many hours during a day, that's a gift, people. It's a gift. All right. That's what I'm trying to say. Like, you should thank your teacher for taking care of your kid for a few hours a day. Oh, for sure. Oh, the school counselors. Oh my gosh. Yes. Oh, I can't even. Yeah, it's tough. They deserve fruit baskets, all of them. Fruit baskets. Right. Mandatory reporters. It's up to the parents. Yeah, I agree. Then they try to tell you well, yeah. I mean, it's a lot. And there's no authority. The teachers don't really have any authority to do anything. Like, oh, okay, I'm sorry, go sit in the Zen room and, meditate with your water garden. Like, sorry you're feeling this way. Like, what are we doing? Oh my goodness. What happened? Yeah, so we're talking about the Crumbley case. So this was a case that went to trial this past week here, where we have the parents purchased a weapon for the child, for the kid, and the kid harmed Oh, Starbucks instead. Excellent point. The kid homicided four people. We had detention. Not guilty based off. I don't know. I don't know. We'll see. We'll see. We'll see what happens. Had one kid, not hundreds. Yeah, that's the other thing too. Yeah. What about parents who raise kids right and they still? Yeah. I mean, yeah, that's a good point too. I mean, your parents can do, or single mom, single dad, single whatevers, or doubles. I mean, who even knows what's the best? But the parent figure raises a kid to be amazing, and the kid still, goes off into la la land. Like, yeah, how do you know? How do you know? I agree, Jay. I agree. There should be a process there. That's just responsible. Who gives kids? That's a good point too. That's a good point. SWAT's really intense training by a coach. Yeah, I mean, I don't know. Any verdicts yet? Nope, not yet, Greg. So the jury started deliberating this morning. My understanding is that they have been let go for the day. So they're done for the day, but they'll be back again tomorrow. There's kids who've been neglected and don't. That's very true, Brad. Very true. And that's a good question also. I mean, this kid, so he didn't get the attention that he wanted from his parents. He had a whole bunch of really traumatic, sad things happen all at once. And when you mix all of those things up together, was that enough to be like, this kid really needs help when he didn't need help before? Or did he need help and should have been getting help all along? I mean, it's so difficult to tell. It's difficult to know. Now, with the demons in the house, everybody, as a side note, she said that they were just joking around and that they were being sarcastic. Meanwhile, he wrote in his journal that if he tried to tell his mom that he needed help, she would just laugh and say that it was a joke. I think we have a sarcasm issue, everybody. Listen, I'm putting it out there and I'm standing by it. I think that there is communication problems because sometimes we're so sarcastic, people don't realize when we're serious. So was he serious or was he not? The parent couldn't tell. No, the jury has not decided, Cynthia. Not yet. Mixture of parenting, teaching, treatment by others. I agree. That's what I just said. All right, Susie. Great minds think alike, Suze. That's why. That was not a joke. Yeah, I mean, that's the thing. How do we know anymore? And our kids, how do the kids know when the parents are joking? How do the parents know when the kids are joking? Like, there's a breakdown in communication here. Parents can be jerks to their kids for laughs. Oh my gosh, Thomas. So true. So true. I'm all in my kids' business. Good for you, Emal. Go for it. Pay attention to your kid. Yeah. Well, and what does that look like too, though? Because she said, we didn't look through his phone or his social media or his diary. So that's another question. Should parents be looking through that? Or do teenagers need a level of privacy? Does that make it worse for them if they know that their parents are going to invade their privacy, their social medias? Come back to start delivering. Yes, that's right. That's right. They'll be back again tomorrow. Yes, they should. I mean, should they? I don't know if that's appropriate or not to go onto your kids' laptops or whatever they have or on their phones. Level of privacy if they've earned it. Absolutely no privacy. Okay. No privacy till you're out of the house. Well, yeah, I mean, I can see how if your privacy means I wind up in jail, then yeah, I think that's a big one. Oh my gosh. You talk to them, not at them. Talk with them. You get to know them for who they are. Oh, I love that. That's really good. That's a really great one. I even delete what I want. Well, yeah, I mean, again, even if parents don't expect, what were they concerned about? Yeah, they were exactly. She was concerned about self-harm after it had happened. So that's a really good question. Depends on the situation and the child. Yeah, I'm with you on that. Danielle, it's really a case by case situation. It depends on the child. It depends on the situation. Oh, thank you for the roses. Very nice. I appreciate that. Only when I suspected something. Well, right. And the other thing too is like, parents can be sneaky. Like, be sneaky about it. It's not like back in the old days where parents were just bumbling around through your room and you're like, Mom, I can't believe you're in my room. It's like, we know how to be sneaky. We can be sneaky if we need to. Like, there's no rules against lying to your children, technically, or going through their stuff. I mean, I'm just saying. If your kids trust you, you don't need to pry. True, true. But I'm just saying, they can be very sneaky. Well, you know what I'm saying, Olga. Right. Trust until you have reason not to. I was like, oh, that's wonderful, Karen. That's wonderful. That's what we all would hope for. What we would hope for. Was in high school, I'd take my mom's check and take cabs places when I snuck out. Oh my gosh. Oh my gosh, depends on the kid. Well, we all did crazy stuff. I myself was a bit of a rule breaker. It's for their own good. You're the parent. Well, yeah. Wouldn't it be negligence? Yeah, you gotta watch it. You gotta watch it, and it's for their protection. It's for their safety. And I think you can really justify a lot of things when you say, look, I'm trying to protect you. Now, when you're 18 and you're out of the house and I'm not responsible and I can't go to jail for your bad choices, then, have at it. But until then, oh my gosh, lemonade, thank you. I can go to jail. Right. I'm willing to go to jail for you. Sometimes it's not your kids. You find out sometimes it's their friends. Well, true. Yeah, that's true. Might not be obvious signs, but there's signs. Doubt you broke the rules. Oh my gosh. Oh, Kristen. All right. Quick story, everybody, before I sign off. So here's my rule break. This is a terrible one, everybody. You have to not judge me. All right. This is just between us, just between you and me. I'll tell you my terrible story, but I'm going to have to edit this part out for my mother. So... All right. So, okay, here, I'll tell a story. I don't think that you did hear it. Oh my gosh. Okay. So my mother, my mother is deaf. All right. And so back in the old days, we had a machine that she used in order to make phone calls. All right. Now, when you use the machine and they would call to the other way, they would have someone that would say whatever you're typing out. All right. But it would just be an operator. So it was TDD or TTY. Yes. So, but the thing was, you never knew who was typing on it. So let's just say you didn't want to go to school. Technically, you could put the school number in and type it in, claim you were a mother, and claim your child was sick. I'm just saying you could do that. Oh my goodness. So I may have called in on my mother's device a few times. I may have skipped school. Don't tell my mom. Mom, I'm sorry. Don't listen to this part. Don't read the captions for this part. We're turning captions off. Oh my goodness. I did. I totally did. Oh my gosh, I did. I own it. I know I own it, but the statute of limitations, have run. What was something fun? Well, I'll just save those stories for another night. But there was one afternoon that involved Burger King and a Camaro. Oh my goodness. I would have done the same thing. Well, I feel better. It's all in good fun. It's fine. We used to cut and have the beer. Oh my goodness. Oh my gosh. Oh my gosh. I know. No, I had some fun. But in high school I was busy. I had some I had jobs. I had stuff. So I was pretty busy. Oh my gosh. Yes. Well, school was like, school was lame. But I don't recommend that. Go to school, everybody. We're at 18 and older for tonight. Oh my gosh. Caught me practicing your signature. Oh my gosh. Karen, okay. So one of these days, here's a side note. All right. So one of the days when I called in, oh my gosh, my mom came home over the lunch hour and she couldn't hear, right? So I'm in the basement. And I thought, well, if she looks in my room and sees me, then she's going to know. So I hid in a closet in the basement. But she came home because she needed something out of the closet. So she opened the door and was like, what the H is going on? And I was like, nothing. Like, you're not seeing anything. This is all an illusion. Oh my gosh, I got into so much trouble. Oh my goodness. She was not happy about that. That was really when she started taking the TDD machine with her. She got an extra bag and she started carrying it around. Oh my gosh. Yeah, I was grounded. Oh my gosh. Yes, indeed. But yes, so that's my fun story. Yes, I know the picture's not funny, but we are talking about parents here, so it's okay. You tried the Jedi mind trick. I did, but it didn't work. It did not work. Take me out early and found out I skipped. Ooh, that's a tough one. She did what she needed to do for a kid. Yes, she did indeed. My mom was very, oh my gosh. No, they've not come back with a verdict yet. Not come back yet. So I was reading through the Court of Appeals. I'm going to have to bring it down now, everybody. Get serious again. I look like it's mask. Yes, I try to turn off any filters when I'm showing paperwork, but sometimes it doesn't work. So sometimes the filters get in there. So I know, having to holler TDD everywhere. I know. She was my poor mother. Oh my gosh. Oh my goodness. I'm gonna need to call her and tell her I'm sorry. I don't know if I've said I'm sorry enough. But anyway, so that was it for tonight, everybody. I've said too much at this point. Oh my gosh. But we'll keep an eye. Yes. It's nice now that we can do video calls because she can read lips very well. So it's wonderful. Anyway, thank you everyone for joining me for tonight. This was a difficult subject. It was, I think, okay to have a couple of laughs at the very end to try to lighten the mood a little bit. So, yes, thank you all for joining me. I will be back on Wednesday, everybody. I'm not sure exactly what we'll be doing on Wednesday. We'll see. We've got a couple of things that are coming down. And then I do plan, oh my goodness, thank you. I do plan on going live on Thursday with the Supreme Court arguments, but I will go after the arguments so that I can pause them and we can kind of have a discussion. So I think I will go live and play the arguments, but have it after they've been recorded rather than at the time. So that should be pretty fun and interesting. So with that, I will go ahead and sign off for tonight, everybody. I will be back at 7 o'clock Central on Wednesday to give everybody updates and to hang out. So thank you all for coming by tonight. Always wonderful to see you. And thank you to the moderators as well. You've worked so hard. I really appreciate it. So have a great night, everybody, and I will see you again on Wednesday.